Hey, good day, everyone. My name is Stephanie Wellman, and I am joining you from the Caring Society. I am joined with Dr. Cindy Blackstock and David Taylor. Today, we're going to be talking about long-term reform of child and family services and what's next. So as I mentioned, I am joining from Caring Society office at unceded, unsurrendered Algonquin territory in Ottawa. Very delighted to join you, and I'm going to turn it over to Cindy and David to say hello, and then we'll jump right into our discussion for today.
So a very good day to everyone. I'm Cindy Blackstock. I'm Gitsan. I'm the Executive Director of the First Nations Child and Family Caring Society. Honored to work with Stephanie and really honored to have David Taylor as one of our skilled counsel on this long-term human rights case, along with his colleague, Sarah Clark, who's not with us today.
Thanks very much, Cindy, and nice to be here.
Great. Welcome, everyone. So we're going to dive right in. As I mentioned, today we're going to be discussing some key decisions that were made regarding long-term reform of child and family services and discuss what the next steps are. So Cindy is going to go first with a presentation, and then we will have a Q&A period.
So just to start off, I know everybody's seen the headlines, Chiefs voted against $48 million. Well, we want to take a closer look at that because actually I don't think that's what happened. I think that the Chiefs really made a vote for good governance, for accountability, and for ensuring that the discrimination stops now and forever. And that was really through these two resolutions, 60/2024 and 61/2024, that were passed after the headlines splashed across the news in Calgary. The Chief said, what was presented to us was not adequate. What we need to do is replace it with something different. And they had done the hard work about the something different with their experts across the country. And that's why those resolutions got such significant support. Well over 90% of the First Nations in the Chiefs Assembly voted for these resolutions. So this really is driven by the rights holders. Next slide. So I want to disclose, as we always do, to be transparent ourselves at the Caring Society. We're a co-complainant in this legal case, which is the Canadian Human Rights Tribunal case. I'm going to get into that in a minute, just as a reminder for all of us about what it is. We respect the other parties who did negotiate the draft final settlement agreement, which was not agreed to by the Chiefs. But we have very different perspectives than they do, and we'll get into what some of those different perspectives are. We're independent. We're not a political organization. So here are some highlights of what we're going to talk about. One is, why wasn't this a good agreement? Some people have said, even in the news, I was asked, well, nothing's perfect. Well, there's a difference between nothing's perfect and not being adequate. And this was the latter. We're going to talk about what those were in those resolutions from the Chiefs, how those resolutions are being fulfilled, and the work is already underway. And we're going to talk about a new entity called the National Children's Chiefs Commission, which is going to oversee all the long-term reform in the Canadian human rights case, both on child and family services and Jordan's Principle. So let's start at the very basics. So this case was brought under the Canadian Human Rights Act, as alleging that Canada was discriminating against First Nations children in child and family services and Jordan's Principle. Filed in 2007 with the Assembly of First Nations and the Caring Society, and against the Government of Canada. Fast track up to 2016, the tribunal substantiated that discrimination and ordered Canada to immediately cease its discriminatory conduct. But in the great wisdom of the tribunal, they had seen through the evidence of the case many opportunities for Canada to become aware of its discriminatory conduct, the harms for children, and most importantly, the multiple solutions that were before it to fix it, and they didn't do it. So they held on to jurisdiction, which means they can make further orders to make sure that the discrimination stops and does not recur. Next slide. So when we think about this, we think about negotiations, we heard a lot about that, but that's only one way to kind of bring things to an end. And when I talk about bringing things to an end, it's not to bring the case to an end. That's not what the Canadian Human Rights Act requires, and it's not what the Chiefs want. What we want is to end the discrimination towards the children and families that the tribunal found in the first place. That's what the end looks like. And there has to be safeguards after that, so that if there's any backslipping, that can be detected and also remedied effectively, even if Canada is not willing to remedy it on a voluntary basis. So what happened here is that some of the parties went off and they decided negotiation was the only way that they wanted to resolve the case. But that was only one pathway, and they chose to negotiate in a confidential space that required the agreement of Canada. It also set out that there needed to be approval by the First Nations leadership. And then once that was given, then you would move on to the tribunal. So that was one process. But then we also have, and we've had over 20 non-compliance and procedural orders in this case. We could just bring a motion against Canada once First Nations have a solution they're comfortable with and litigate against Canada. This is a legal case. It's not just a regular straight up negotiation. What we found to be probably the most effective in the long history of this case is a combination of both. Get Canada to agree, and most importantly, also to fulfill its agreements, because on Jordan's principle, we've had repeated breaches even when they've negotiated an agreement. But do that, and also go back to the tribunal on more narrow questions about interpretation of their orders so that we can make sure the discrimination stops. Next slide. So what do you need to know? Well, first of all, about this draft agreement that was rejected, it was 9 years. And I'm going to have David talk to you about that later, whether or not that's going to be adequate. But 9 years and then nothing after that. There was the draft final settlement agreement you've heard about in the news was on Child and Family Services, not on Jordan's principle. But the parties to that draft final settlement agreement, which are the Assembly of First Nations, Chiefs of Ontario, and Anishinaabe Nation, and Canada, have all said that they wanted to finish a Jordan's Principle final settlement agreement by March 31st, 2025. Canada did not discharge its duty to consult First Nations. Instead, it relied on the AFN to do those negotiations or those presentations to them, and also to the Chiefs of Ontario and NAN in Ontario. There was no process for getting amendments or discharging them by the parties. It was presented, in my view, this is my view, as almost like a fait accompli, that there really wasn't going to be any major changes. And there was no opt-out provisions. And then within 30 days of approval, they were going to move on to the tribunal. But of course, the Chiefs did not approve this agreement. So that's just an echo of the two pieces of the agreement in the stages that you need to finalize things. First is to get the leadership on board with what they think is the solution. And the second is the tribunal has to be satisfied that it ends the discrimination and make sure it doesn't happen again. So what were some of the shortcomings? Well, you know, a lot of folks think $47 billion. How can you say no to that? Well, you know, all of us have seen large announcements of money, but then we look at the fine print and it turns out that maybe it's not secure. And in this particular agreement, there's a paragraph in 383 that made any of the monies announced, all subject to Canada's whatever Canada viewed as a required approval process. So really what looked like maybe a 9-year funding agreement quickly becomes an annual funding agreement subject to a lot of discretion by Canada. This agreement also rejected all of the tribunal's orders, which were safeguarding about $45 billion. So this wasn't like all of 47.8 new money. This was, we already had 45 plus. And what did we make enough gains to end the discrimination and make sure that's secure? In our view, when we look at the replacement of the alternative dispute resolution that was supposed to hold Canada accountable was very weak, weaker than the orders. There wasn't a support, the type of support we'd like to see for regional variations. In our view, we'd like to see a national agreement that ends the discrimination, but we've always understood that there are distinct community circumstances and cultural needs for kids. The agreement allowed for that, but not if it costs more money. Canada didn't have to pay for it. It was very Indian-centric, and the governance was something I've not seen before ever in any agreement regarding children and families, in that it was secretive. After the chiefs would have, had they approved it, they would have no more decision-making about it, and they would be seeing the impacts on the ground in their communities, but not knowing even what the decisions are made by these bureaucratic committees. And it was really unclear to us. We saw some citations of different research that's been done on this, but really it was almost like cherry picking the research. It wasn't really highlighting the substantive requirements of it. So those were some of the key shortcomings. And here, just to give you an example, some of the things that were pretty surprising to us is that, for example, the department itself would develop and implement its own training, including on First Nations cultures. Like that's not a step forward. That's not. We have had a lot of good people talk about that over the years, and also that although there was supposed to be independent technical and nonprofits nationally, it turned out they were all controlled by the parties. So it wasn't really accountable back to the communities and back to the chiefs. Next slide. One thing we do want to underscore for you is that in Ontario, there is a special agreement that sits on top of this draft final settlement agreement, and it provided for a variety of things. For example, for Jordan's principal to fund band representative services off reserve. There was also a different ADR that, in my view, and I'll be interested in David's thoughts, but I thought it was stronger than what was in the final settlement agreement. And there also was funds for governance and administration and legal costs for both the Chiefs of Ontario and Anishinaabe Nation. So when we read the agreement and did our due diligence, we also didn't want to just be a backseat driver. So we came up with a bunch of amendments to try and fix it. And we sent those at a very early stage to all the parties. Those amendments were not actioned, but they were on the record, and they were improved. Our first version was improved by suggestions from First Nations and experts across the country. So we've had several versions of this. So what did the chief said? Well, they took a look at this agreement. They had their own experts review it, their own legal counsel. And I should mention, they had no money to do any of that, but they all chose to try and really do that on their own as regions or collectives or individual nations. So they said no to that final settlement agreement, that it didn't meet the basic baseline of ending the discrimination, and that needed to be much stronger and transparent, accountable, and it needed to respect their decision-making. So they passed this resolution 60/2024. It applies to both Child and Family Services and Jordan's principal. And it establishes this National Chiefs Commission. So the chiefs are going to oversee these negotiations or this long-term reform. And that's a good thing. And there's going to be chiefs appointed there by the chiefs in each one of the regions, as well as First Nations not associated with AFN. That group will oversee the negotiations, and they report back to the chiefs in assembly and the First Nations who are not members of AFN, because it's the chiefs who have that decision-making, not this commission. And there's some collaboration between the AFN executive and the National Chiefs Commission to make sure there is an amendments process, so that if there is some kind of negotiated litigation pathway, that people have an opportunity to improve it. Next slide. So there were two resolutions. The second one is really about setting out some general parameters for the negotiation. Like you can't negotiate against all the wins we've already gotten through kids through the orders. We need to make sure that it's not time limited, that Canada's held to its obligations to First Nations and to kids. Canada needs to get a new negotiations mandate, come to the table in good faith, and actually do this in a way that they always talk about respecting the rights holders. Well, the rights holders are the ones who voted for this resolution. That's who they need to be respecting. And make sure that, we're following through and not setting aside those tribunal orders in favor of something that's not stronger. So the resolutions do call for reporting back to the chiefs, because that's the whole thing about making sure there's transparency and accountability. And there was some technical work that needed to be done. So there's a group called the Informal Technical Working Group. It's basically a group of volunteer technicians from across the country. There's no funding associated with it. And the circle keeps on getting bigger of these technical experts, and people picked up various pieces to assist the leadership to fulfill the responsibilities of of those resolutions. Next slide. So what have they done? Well, the Expert Advisory Committee, for those of you who don't know, is an independent creation of the tribunal. It's an independent committee of experts, and they have drafted their own terms of reference, and that has been complete. National Advisory Committee, group of technicians, that has been done. And we have a bunch of other documents that we hope to have for review of the Children's Chiefs Commission and the Chiefs at Large, done by the end of say, November of 2024. So one of the pieces that we'd always like to let people know is there is something called interested party status at the tribunal. And that's where you have to come in. David can explain it better than I can. I'm not going to give you too much information here, but to say if you're a First Nation or a group of First Nations, even better, or regions that have a particular point of view that's not represented by the parties, you can make an application to the tribunal to actually represent your views at the tribunal directly. Next slide. So for regional leadership, I think the key thing is making sure that you have an appointee to this Children's Chiefs Commission. We've already known for several of the regions that's underway, and we know that chiefs in every region have their own processes, so just keep on advising of that. If you're a technician in a region, make sure your leadership has seen those resolutions 60 and 61. They're on our website. They're also on AFN's website. I think it's really important that the AFN convene the National Advisory Committee so it can discharge its work. Those meetings stopped in February of last year, and it's really important that AFN brings those meetings together so that the technical work can be done. I just really want to thank everybody on the volunteers on the informal working group for being the stopgap measure for now. And I think that it would be good to get an update on what's happening with these resolutions, 60 and 61. We haven't heard a lot other than we do acknowledge that the national chief on the website says that she has sent a letter to the minister asking for funds to implement the resolution. And we need to make sure that Canada implements this thing. They keep on talking about rights holders. It can't be just let's listen to rights holders only when Canada agrees to them. The discrimination requires more than that. And so does their relationship of respecting First Nations rights. So that's it for me.
Thank you very much, Cindy, for giving an overview of some of the shortcomings in the draft FSA and the discussions that were held in Calgary with First Nations leadership. I'm going to turn it over to you, David, to provide some feedback and remarks. Oh, you're on mute.
Sorry, that pesky unmute button. So I think one of the key things to bear in mind is the nature of like what is this legal proceeding? This is, like Cindy mentioned, it's a complaint under the Canadian Human Rights Act. It was started in 2007, So, about 17 and a half years ago, and it proceeded through to a decision on the merits in 2016 after, I think it was about 85 days of hearings before a three-member panel, the Human Rights Tribunal. And the Human Rights Tribunal has essentially stuck around to supervise its decision and make sure that it's implemented. And the very first decision this Human Rights Tribunal gave was 160 some pages, almost 400 paragraphs. And it really, came down to a very simple point at the end, which is that there's discrimination going on in Child and Family Services on reserve and the implementation of Jordan's principle, and it should stop and it should not happen again. And the tribunal really gave quite a large mandate to the government to end the discrimination and prevent it from occurring. And through further orders of the tribunal, made it clear that that change had to happen with the involvement and with consultation of those who are most impacted by the change. And so, where we find ourselves now, which is, what's next is in this process, which is to really, as Cindy said earlier, is to, not just end the case, it's to end the discrimination and prevent its recurrence. And so and even the draft FSA was, premised on getting approved by the tribunal. And that's really at the end of the day, the ultimate question is, are the measures that come up through negotiation or that are coming up through negotiation supplemented by some help from the tribunal, in terms of resolving areas where there isn't agreement, is that going to do the job of ensuring that the discrimination ends and doesn't recur? And so when we look at that, it's obviously a very broad complaint that touches, First Nations kids from one end of the country to the other. But it's part of our federal system that's existed since the 1970s to make sure that individuals can get the full benefit of services that are available to them, regardless of any of their characteristics that might cause them to suffer discrimination. And we know, going back generations, that there have been those characteristics for First Nations kids that have caused that discrimination. And so the mission here really is to fulfill the promise of the Canadian Human Rights Act and ensure that First Nations kids can live free of that discrimination when they're looking at the child and family services that might be applicable to them, or more generally with Jordan's principle, their access to program services and supports. And so obviously the focus here is child and family services, because that is what the draft final settlement agreement was on, but that's kind of the broader context in which this is all situated.
Thank you for that, David. Cindy, I wanted to turn to you to ask you as well about what this case is all about. One of the things that we heard during the assembly in Calgary was that we're just talking about a program and this isn't about rights. I wonder if you have any comments on that.
Yeah, well, this is about rights. In fact, it was human rights that the tribunal found were infringed for each of these children and the families and the young people. This is not about a quote program. In fact, I think using that type of language really takes away from the rights of Indigenous children writ large through the UN Declaration on the Rights of Indigenous Peoples and the Canadian Human Rights Act, and indeed the many First Nations laws that emphasize the obligations and the basic things that need to be in place for children. The word rights might not be used, but it's an obligation and a duty to ensure that the most sacred among us, that being the children, have their needs, and that includes their cultural and spiritual and language needs, met. So using the word program, that's something that I would really recommend against not using. This is clearly about rights, and we can't forget, sometimes when we talk about First Nations rights holders, we think about the First Nations governments, and they are, but First Nations children are also rights holders, and so are their families. And it's to them that we owe the duty to eradicate this discrimination.
Thanks for that, Cindy. And on that subject of eradicating discrimination, the draft FSA was a 10-year agreement. Can you share some reflections about if discrimination can only be time limited, or a commitment can only be time limited to ending discrimination for First Nations children?
Yeah, go ahead, David. I have my,
Okay.
but you can tell them what the law says.
Yeah. Well, I think the reality is there was no time limit on the tribunal's orders. The goal of the orders is to end the discrimination and prevent its recurrence. And so having a solution that's time limited with no sense of what's happening after that, I mean, it really raises the question, what happens the next day, right? Because we'll still have kids, we will still have the structural factors the tribunal has very clearly identified that underlie, sorry, the greater needs that lead to the involvement of child and family services. Obviously that is something that needs the work of, truth and reconciliation, and decolonization needs to be to move towards eliminating those underlying conditions. But I think the reality is that's a longer than a 10-year project. I was in law school, and I had the great fortune of seeing the late Murray Sinclair come to speak to a group of about 24 of us when he was the chair of the Truth and Reconciliation Commission. And he said at the time, and he said in many places since, and it's an idea that's reflected by many, it took 7 generations to get to this point, and it'll take 7 generations to fix. This is a project with a very long arc to it. And so the idea, of 10 years, which is, maybe a generation, when we are, hopefully a generation into progress in the right direction here. And then there would be really no guidance after that, because the challenge with the draft agreement is that, it's an agreement that sets out, parameters for how things will operate for 10 years, but in so doing, it replaces the existing orders from the tribunal with the agreement, and then the agreement comes to an end. And certainly, to be fair to the draft agreement, there's a process, involved in that agreement about studies to look at the footing of the program going forward, but there's really no concrete assurances, and it's left to a dispute resolution mechanism that itself, other than potentially resolving some final disputes about what looks next, doesn't extend beyond the life of the agreement. And so it's just a situation of considerable uncertainty that communities would be looking at in the mid 2030s. And that's not really the spirit of the orders. The spirit of the orders is, took from 1990 to 2016 to have the discrimination identified and addressed in a way that involved binding orders. And there were studies in 2000 and 2005, NPR and Wande, in 2008 by the Auditor General, in 2011 by the Auditor General as well, by 2009 and 2012 by committees of Parliament. And all of those things didn't address the discrimination. It was the Human Rights Tribunal's orders that did that. And so where is the effective, means and mechanism to ensure that after the end of the 10-year term, matters continue to be addressed? And so that's really the chief problem, at least that I see. And that's not there isn't it's not like as we're learning in the US, the two-term president. It's not a built-in time limit under the Human Rights Act. It's a requirement to and under these particular orders, a requirement at the end, and not only end the discrimination, but prevent it from happening again.
Yeah, and this to me rings of a long colonial strategy by Canada, where they put out a carrot and then they want you to jump for it. But then the main problem remains unresolved for generations to come. And I thank David for mentioning the Honorable Murray Sinclair. Just a treasured human being who brought such important work for children. And if we look at the survivors of residential schools, their top priority was child and family services and Jordan's principle, exactly what we're doing here. And they didn't say, just fix it for 1 year or 2 years or 3 years. They said, fix it so that our grandchildren don't have to go through it again. And that's That's what we have to do. That is the minimum standard. It's not we've made best efforts to do it and then we'll just do it for 9 years. No, that is the baseline that we have to achieve.
Thank you, Cindy and David, for that. So my next question is about what's next. When First Nations leadership held their gathering just last month in Calgary, they made the very courageous decision and came together to reset the negotiation process and set a path forward for accomplishing long-term reform. So, Cindy, is there anything that you would like to see happen next, or what you anticipate should happen next?
Well, one of the things that I want to recognize is that First Nations and their experts have been working over since the decision came down to really come up with costed out, economically viable solutions that could contribute towards ending the discrimination. I want to just acknowledge for a moment that money isn't the complete answer. It's how the money is actually structured and whether it'll make a big difference for kids. That really matters. In fact, in some cases, that even matters more than the amount of money. Because if you have money, but it's so restricted or it's so bureaucratic that it actually can't respond to the needs of kids, then we're going to be back at square one too. So let's make sure that we get that right. We have the evidence to do it. We need to build on that. My view always is, and I just want to recognize everybody who came before we even filed the case, but if we work collectively as a circle of technicians, and we do that at the leadership as the Children's Chiefs Commission is anticipating, we actually will come out with a far better result for kids. And that far better result for kids is also going to be a far better result for Canada. I mean, honestly, I was really surprised that Canada would agree to a secret governance mechanism over public money, for example. That is not something that you generally do. Every group needs accountability, and that includes the Government of Canada, which, by the way, was on that secret committee. So you need to have accountability and transparency. We have these evidence-based processes. We have the benefit of great leaders and experts across this country who have been doing this work. We can really land a solution. It won't take much longer. And frankly, I think it is longer to do a process that doesn't work and have to reset it than it is to do it right the first time. That was my mom's advice to me always, is do it right the first time. It might feel like it takes longer, but it's a lot less time than having to clean up a mess and restart. We're going to clean up this mess and we're going to restart, but we're going to learn the lessons from the past. And when it comes to Jordan's principle, I think the Chiefs have been clear that they expect that to be done right the first time.
Thanks for sharing that, Cindy. It sounds like the Caring Society is deeply committed and eager to land long-term reform. In the meantime, while long-term reform is being worked on, what are the safeguards and protections that are in place for First Nations children right now?
I might take a stab at that one. So I mean, we have the tribunal orders that are still in place. There are ongoing obligations on the government. There are legal orders that are binding on the Crown, and that the government has been following. In some cases, with sometimes varying degrees of compliance, but those have been in place now for almost 7 years. And so the chief ones to look at are the actuals orders that were made in 2018. So there are requirements for small agencies to be funded at the actual costs of their operations, and for agencies that are not small agencies, i.e., those that are serving more than 1,000 kids, are eligible for actuals funding for building repairs, legal expenses, and intake and investigation related expenses. There was an actuals order on prevention, which was overtaken in 2022 by a per capita funding based order, and that requirement to have per capita funding it was 2651 last year or something like that, and will go up again with an inflation factor, or should go up again with an inflation factor in 2025, remains in place. So those are bedrock items that addressed what the tribunal identified in 2018 as being essentially the areas of greatest need to ensure that as we put it at the time, the sting of discrimination was taken out while the overarching reform to the program was being worked on. And then, of course, another significant component are the capital orders, which continue as well. So for infrastructure related to child and family services, those remain in place. And so those tribunal orders are really, like I said earlier, the bedrock and haven't been changed or displaced in any way by the negotiations that have happened over the last couple of years.
Thanks for that, David. I really love the analogy of a bedrock. I think that really shows how safe and secure those current tribunal orders are. So I'm just gonna open it up to see if anyone has any final comments or reflections, any messages that they would like to share with First Nations leadership or technicians that might be watching right now.
Well, I want to say how impressed I was at the meeting in Calgary, regardless of the views, the position on the vote, that people often for the first time, the Chiefs didn't see this agreement until late in the evening on July 11th. It's during a time when they're dealing with a lot of climate crises. They're also dealing with their staff are on vacation, like many people are doing with family time during the summer. But they all rallied their best efforts to make sure they were informed and could make a good decision. And that is always a good day for kids. And I just really want to acknowledge that. The second thing, though, is I also heard a lot of dialogue, some confusion with compensation. We even heard things like, oh, they're representative plaintiffs for the tribunal. Just be sure that the compensation for the discrimination towards those who are already hurt by Canada, that's an entirely separate matter. Has nothing to do with what the Chiefs were discussing there in Calgary. And will not have any impact other than when those monies roll out, do we anticipate there will be higher service needs for Jordan's principal and child and family. So that's something to watch for. But, what the Chiefs voted on had nothing to do with that. I think that's important to say. And there are no representative plaintiffs in a Canadian Human Rights Tribunal proceeding. The other important thing is I heard people talk about the status quo. The Chiefs voted for the status quo. I don't think that's a fair or accurate characterization of what happened. In fact, the Chiefs expressly did not vote for the status quo because they have those two resolutions, 60 and 61, that provide a pathway forward. What they said is that the agreement, based on the text, on the merits of the negotiated agreement, did not achieve the basic human rights standards that their kids deserve, and that we have to do better. That was what the decision was made. That's how I'd characterize it.
Thanks, Cindy. David, did you want to add any final remarks or reflections?
It's always dangerous to be the one to have to sum up after Cindy. But I think the main point I'd like to get across is just, I think one thing the tribunal has always been very mindful of is that the solutions that come about as a result of its orders have to work at the level of each community. And the tribunal is very well aware that each community has its own historical, cultural, and geographical context. And the way that is most effective or the best for I think making sure that those historical, cultural, geographical contexts are all understood is for folks to participate. And so I think like Cindy was saying, is very impressive. In Calgary, everyone, the Chiefs being there to speak really for their own realities of their communities. And that's certainly something the tribunal has been very alive to. And so that's it's expression of gratitude for folks for being so engaged in this process, because it's a vital one, and it's made more effective by folks speaking out to their particular and distinct realities, because that's what the Human Rights Act is trying to address.
Thanks so much, David. So I want to say thank you to Cindy and David for joining us and having a little talk about what's next with long-term reform. You can stay updated by visiting the Caring Society's website. We're always sharing updates and any progress that's happening, including info sheets and everything you need to know. So I encourage you to check on our website regularly. And if anyone has any questions, feedback, please feel free to reach out to us. We're always very delighted to hear from you. So we wish you a good day and thank you for joining us.
Thank you for having us, Stephanie.
Thank you, Stephanie.